Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. So we are going to discuss the first public interest litigation on the human rights. So this case you can read as Hussainara Khatoon versus Home Secretary, State of Bihar, 1979, and the judgment was authored by none less than Justice P.N. Bhagavati, who is the propounder of the public interest litigation. Please remember, this deals with the legal advice. So Article 39A, you can read it as the first public interest litigation case. So here, please remember, Justice Douglas, Justice P.N. Bhagavati mentioned the wordings of or the verdict of Justice Douglas in John Richard Anger Singer versus Raymond Hamlin, where Justice Douglas said, the philosophy of free legal aid, the philosophy of free legal advice as an element of fair procedure, right, found in the judgment of this checklist. So, a right to be heard, it would be of no avail if it did not comprehend to be heard by the court. A right to be heard. So, the accuser has got a right to be heard. So, right to be heard through counsel, because the accused does not know the legal points. So, he has to be heard through advocate. But all the people are not able to engage the advocates. Therefore, free legal aid is necessary. If the court doesn't respond to the free legal aid, where he can go? Definitely to end in conviction. This is the words propounded by Justice Douglas in that famous case of Anger Singer. But anyway, so please remember, the state has got a duty. The state cannot shirk its duty. The state cannot avoid its constitutional obligation to provide speedy trial to the accused when he pleaded the financial or economic constraints, or administrative ability. Sir, I don't have money. Then justice should not go away from him. He should give him the free legal aid. Right. Now, we'll go to the facts of the case. In the year 1979, there was a news published in the Indian Express about the incarceration of the undertrial prisoners in Bihar jail for longer periods, not only in Bihar state particularly. So, on seeing this, advocate Kapila hingorani, she filed a public interest litigation. That's why she is called mother of public interest litigations. So actually, she came to know that 17 under trial prisoners were languishing in jails in the state of Bihar, right? So the Supreme Court took it as a public interest litigation, and as I told you, it's the first public interest litigation, and asked the state of Bihar to provide year by year breakup of the persons in jail and persons suffering in jail, persons kept in more than the conviction period. All the details of the under trial prisoners were asked, and actually they were asked to be divided into two categories: serious cases and non-serious cases. And the result has shocked the Honorable Supreme Court of India. Please remember, many of the prisoners were charged with petty offences, and they were sentenced to just some months, but they were kept in the jails for more than 5 to 10 years. So, of course, the reason is also there. Normally, at the time of giving conviction, the judges will say that he will be released on expiry of the sentence on his providing a security or bail with two sureties for an amount of so and so. So, these people are not able in a position to get the sureties, therefore they have been stranded in the jails, right? And you may be getting a doubt, who is this Hussainara Khatoon? This Hussainara Khatoon B, she is a Bangladeshi woman. She, along with 5 others, actually they were detained under protective custody for more than 4 years. So even though the government of India issued orders to release them, but still they were not released. So in their name, another case was filed, Hussainara Khatoon. The public interest litigation coupled with this Hussainara Khatoon case, actually as propounded by that Kapila hingorani, they have actually literally shocked the legal fraternity. Ultimately, even though the government issued orders to release them under Foreigners Act, but please remember, they were not at all allowed to go back to their country, that is Bangladesh. Of course, here you have to know the reasons also why they are not able to furnish the sureties, why they are not able to go on bail, because of the poverty, because of normally the jail authorities, they also stated why these people are languishing in jail. Jail authorities stated that most of the cases they have been pending for expert opinions. There is another problem, and sureties is the most common problem. So please remember, in this case, the Supreme Court clearly held that the long-term detention is violative of Article 21 of the Constitution of India, right? So in bailable offence, they have to given bail with self-surety. They have to released immediately, and if they want to contest the matter, free legal aid should be given to them, because justice delayed is justice denied. So as a result of which, 40,000 prisoners in the entire country, 40,000, I repeat, in the entire country, they have been released. So we have to congratulate the mother of public interest litigations, that is Advocate Pushpa Kapila hingorani in this issue. Normally, most of the as students, we also got confused why this case is named as Hussainara Khatoon. So she is a Bangladeshi woman. She was languishing in jail for more than 4 years under Foreigners Act. The punishment itself is only 1 year, Foreigners Act. Then how 4 years has come, nobody knows. But anyway, so this case threw light as the first public interest litigation case, and so many people who were detained illegally, and not illegally, who were detained for longer periods for no fault of them, they have been released. Very good judgment. Please remember this judgment, and you can quote it whenever the human right violations question comes into the topic. Thank you.